Good morning and good afternoon. My name is Kathleen Regan, and I'd like to welcome you all to a LexisNexis complimentary CLE eligible webinar titled Know How to Protect Your Workers When Nature Gets Nasty. Before introducing our speakers, we have a few announcements. If you have access to live streaming, we would encourage you to use that method to participate in today's webinar. Please take note of the survey that is available to you. We ask that you please complete the survey today, as it provides excellent feedback for us so that we may continue to bring you outstanding programs that meet your needs. The panelists welcome your questions. You may submit your questions via the Q&A section of the platform throughout our program today. The panelists will try to address as many audience questions as possible. Please keep in mind all questions may not be answered due to time constraints. No questions will be asked verbally, and instead should be submitted using the Q&A section of the platform. For CLE accreditation, we will announce 2 5-digit codes randomly throughout today's call. After today's call, you will receive an email from LexisNexis within 48 hours, which will direct you to download your CLE certificate from LexisNexis University using the participant codes provided. Should you have any questions, please contact the CLE LexisNexis team at cle@lexisnexis.com. And now I'd like to introduce our speakers. Complete biographies are included with today's PowerPoint. Jennifer Kearns is a partner at Duane and practices in the area of employment law, both in the transactional and counseling arena and in the litigation context. Ms. Kearns has over 2 decades of experience in counseling and advising employers on all aspects of employment law under federal and California state law. Joanna Rich is a senior associate at Ford Harrison and concentrates her practice on the representation of employers in labor and employment law matters. She has extensive experience handling a wide range of employment issues, including conducting internal investigations of sexual harassment and assault, pregnancy discrimination, whistleblower claims, and misappropriation of trade secrets. William Hannan of Oxfeld Cohen represents unions in both the public and private sectors, as well as individuals in labor and employment matters. He received his BA from the University of California, Los Angeles, and his JD from Notre Dame Law School, where he served as production editor for the Notre Dame Journal of Law, Ethics, and Public Policy. Speakers, the floor is yours.
All right, good morning. This is Jennifer Kearns. I'm today's moderator, and I think we have an important and very timely webinar for all of you today. Now, anytime there is severe weather or some natural disasters, a whole host of things come to the forefront for businesses. And these include protection of the physical business premises, protection of business assets, protection of the business's crucial data like client databases, software code, etc., communications during and after the crisis, and also ensuring the workers' safety. But today, we are going to focus, we don't have time to address all of those, and today's focus is going to be primarily driven by focusing on the employment-related considerations. So we're not going to talk at length about protection of physical assets and so forth. But some of these questions that may arise for employers include, first of all, what if your business shuts down? Are you obligated to pay workers? If the business does shut down, are workers entitled to receive unemployment benefits? Whether you can require your employees to use any accrued paid time off or vacation time if you have a closure in lieu of claiming unemployment. We'll talk a bit about whether warn notices need to be given if you have a facility that is going to be closed permanently or for an extended period. We'll talk about how weather and disaster-related absences might impact attendance and absence policies and whether employees basically get penalized for being out during these times. We'll also talk about how business closures as a result of weather or disaster affect tracking of leaves of absence. There are a number of leaves of absence, most notably FMLA, which are limited in duration and which employers track the duration of. And so question, if the business is closed, should the employee who is out on FMLA have those dates of closure counted against his or her 12 weeks? We'll also talk about whether employees are entitled to take any protected time off in the aftermath of a disaster or severe weather. We'll talk about the attendance policies and some of the considerations you might want to implement and work into your attendance policies. We'll talk about whether you discipline employees for weather-related absences and the potential pitfalls of doing so. We'll address whether workers have a right to refuse to work in inclement weather or in the aftermath of a disaster. And we'll speak to how to respond if workers are stranded at home or work because of weather emergencies, and whether you've got obligations to either get them home from work or what your obligations are if they are stranded at work. And we'll also address how to prepare the business to safely respond, training your workforce how to stay safe during weather events, and what to do if workers are injured and the implications that that has for workers' compensation claims and workers' compensation, income replacement. So I'm going to speak to the compensation issues at the very beginning. And one of the things that you may be concerned about is whether or not you need to pay your employees if there is an inclement weather or disaster-related closure of the business. The rules are as follows. If the employee is a non-exempt worker, that could be an hourly worker or it could be a non-exempt salaried worker, you only pay them for hours actually worked. So if you are having inclement weather and midday through the day, it is decided that the facility will be closed, you only need to pay those individuals for the time they actually have worked that day, not for a full day. I put here a note about reporting time pay. There are certain states, California among them, that says that if you're an hourly worker, you're scheduled to work for a certain number of hours, you show up ready, willing, and able to work, you need to be paid for half of your scheduled hours. That is true when the closure is due to the employer's own decision. I think that if you're in a state that has reporting time pay obligations and it is a natural disaster, I think you're going to be relieved from that obligation. If it's simply inclement weather, which doesn't require the closure of the business, but the employer does so in order to be proactive and careful, I think you may still have a reporting time pay obligation. Now let's switch to exempt employees. If the worker is exempt and has worked any portion of the work week for that work week, you are going to owe them salary for the full work week. If, on the other hand, you have a closure that spans, multiple work weeks, and there's a work week in which your exempt employee hasn't done any work at all, you don't need to pay any salary for that work week. But given our consistently or our ever-increasing mobile workforce and telecommuting, bear in mind that exempt people who do some email checking from home may very well be considered to have worked some portion of that work week. And so this is something that you need to take into consideration. You may have an exempt manager who, from home checks a few emails, responds to a few client emails. That's work, and that may entitle the individual to full pay for that work week, even though your facility was closed due to a disaster or inclement weather. If employees are required to wait at work, it's compensable time. It's waiting time. And so let's say your power goes out during a storm, but you don't release everyone. That's a situation in which you're going to need to pay hourly workers for their time. Similarly, even if you release employees and tell them you're free to go home, but you need to keep your phone on and return to work as soon as we call you, that very well may be on-call time, depending upon what your strictures are. You may say you need to be on call and able to return to work within 2 hours of a phone call. That probably won't be on-call time, but certainly if you say keep your phone on and be able to come back to the premises within half an hour of receiving a call, that would be on-call time, and you'd need to compensate for that. Finally, what about a situation where you've got some malfunction in the workplace as a result of the weather or the disaster, and you've got people who actually say they're going to try to help fix things at work. My example is engineers who are trying to fix down systems, getting them up and running, and the rule is if the individual's work as a, quote, volunteer, close quote, is within the scope of what they normally do for the business, it's not volunteer work, it's compensable work. It's hours worked. So let's talk now about what happens if you've got a work site that is either going to be permanently closed or closed for some extended period due to a natural disaster or severe weather. One of the first things you want to consider is whether or not your business is covered by WARN. You generally need to have there are state counterpart laws, like California has a Cal WARN, but the federal WARN Act applies to businesses with 100 or more employees. And the closure, in order for a WARN notice to be triggered by a plant closing or mass layoff, needs to affect 50 or more employees. There's some other more technical aspects to WARN which we don't have time to go into. But let's just say you've got a business and a site is destroyed in a tornado, and it's going to close, and there were 100 people working at that site. The U.S. Department of Labor has a natural disaster fact sheet, and so normally if you were closing a plant voluntarily that affected 50 or more, you would need to give 60 days notice, written notice, of the intention to close. But in this instance, of course, you know, it's closed because the building no longer exists. You don't have that 60 days. You don't have that luxury of time. And so the natural disaster fact sheet, which again is the DOL's take on how this applies to WARN, they say that if the plant closure or mass layoff is a result of a disaster, you still have to give as much notice as possible. And this is even if the notice comes after the disaster and after the site no longer exists because of the disaster. It suggests that you send notices of closure or mass layoff to the employee's last known address, if possible, even if the same are destroyed. So for example, let's say your computer systems which stored all your employee data have been destroyed and you actually don't know any longer your employees' last known addresses. In that case, the DOL suggests that you try to show good faith by posting physical notices at the former work site. You know, maybe there's a single pole left standing and you can put something there, or providing notice in local newspapers. Now, the fact sheet also goes on to say that an employer whose business is destroyed by a disaster who fails to give notice of plant closure probably won't be held liable under WARN for its failure to do so. But there are reasons that you would want to give that notice anyway. First of all, you may want to be able to rehire these folks or bring them back if the facility is rebuilt. And then certainly there's the public relations angle. So you know, I think the DOL fact sheet is really kind of suggesting if your business is completely obliterated by a disaster, they're not going to be coming after employers for failing to give the WARN notice. But I still think that for an employer that is a going concern, that has operations elsewhere that were unaffected, or that plans to rebuild, I think it's a good idea to give the notice to the extent possible. Okay, so now let me turn to written preparedness plans. And by the way, we will have a Q&A at the end of the conference. I am keeping an eye on the Q&A window, and if I get any questions that are germane to what I'm speaking about in the moment and can be answered quickly, I'll do so. So next, let's talk about written preparedness plans. I am speaking to you from California, which is a little bit different than many other states in the nation in a lot of ways when it comes to employment laws. But that said, using California as an example, some states actually have legislation saying that if you're an employer of a certain size, you must have a written workplace injury and illness prevention program, also called IIPPs. Here in California, that applies to employers who have only 10 employees or more. And so you need to be aware of whether your state requires, or your client states require them to have written IIPPs in place. If you are in such a state, the IIPP is an ideal place in which to merge in your disaster preparedness program and have it in writing. But even if you're in a state in which no IIPP is required, it can be very helpful as an exercise for the employer to try to go ahead and put together a written preparedness plan. First of all, it'll help you identify potential weather and natural disasters that could come to visit your business. For example, here in California, it is highly unlikely that we would consider a tornado a viable disaster that would hit in California, nor a hurricane. But we, of course, have earthquakes, and we have, raging forest fires. So, every geographic area is different, and one of the first steps would be to identify the natural disasters that reasonably could be found to occur in your state of operation. The other type of disaster you'd want to consider identifying are disasters that are specific to the nature of the business in question. The example I give here is in a nuclear energy plant, there's always a danger of a radioactive spill. That obviously is not the kind of danger that would necessarily occur in an office workplace. So you'd want to identify both the natural disaster risks and any unique business-related risks. The exercise of creating your plan can help you identify practices by which you can minimize some of your additional disaster risk. So, for example, if you have a biotechnology lab that works with contagious disease organisms, in any kind of natural disaster in which the facility might get destroyed, that could result in the release of the contagious disease organisms, maybe even causing something like we saw in that movie Contagion. So that is a situation in which the business might be able to identify ways in which it can better secure the organisms into containers that might withstand a natural disaster. Another example, embers from a forest fire ignite gasoline that's been improperly stored within a facility. The fix there, don't store the gasoline improperly within the facility. As part of this exercise in identifying your preparedness considerations, you'd want to think about what kind of space or facility do you truly need to operate your business. Are there other nearby geographic sites that could subsume some of that work if one site is damaged, destroyed, or closed? And those other geographic sites may be within your company or simply might be available space. In other words, if you have a biotechnology lab and it gets destroyed and you don't have any others, are there other facilities in the same geographic region that are available for rent that you could basically use as a short-term or long-term fix? So identify alternative spaces outside your own business that would be appropriate to take on the business if you needed to. Think about what functions of your business could be entirely outsourced if you had to. You also have to think about the fact that if you do relocate the work to another facility, whether you own it or whether you lease it anew, what responsibility are you going to take, if any, for getting the employees to the new work site? Will you provide transportation? That's optional. There's no obligation that if you relocate the work to a new facility, you've got to provide transportation. But frankly, it's something you want to consider from a PR perspective and also retaining your workforce. Finally, if you outsource work, if you take functions out of your business and send them to contractors or other businesses, will this be temporary or permanent? And if long enough in duration, you still have to think about whether WARN is going to be implicated, because if you outsource certain job functions outside of your company, the people who had been doing them within your company obviously are no longer needed for at least a period of time. Now, you're also going to want to consider protection of employee data. And again, we're all very aware of the importance of protecting both the privacy and integrity of employee data, but within the disaster preparedness field, it's important because this is how you're going to contact employees or contact their emergency contacts. So think about how you store that. I would consider duplicating and storing that data in off-site backups or clouds. I think that most employers probably are already doing that. But you also want to think about implementing a program for communications with employees in the event of impending disasters or weather. I know that my law firm uses a commercially available service called Preparedness, and when we had some forest fires out here in California some years back, I remember getting texts and emails from this outside provider, and these went out to all the Duane Morris attorneys and employees in the area, letting us know the status of the fires, whether the office was open or not, and so forth. So there are, again, I only know of Preparedness because it's the one that we use, but there are outside commercially available disaster notification services. Now, you also want to think about impact upon leaves of absence. And so this is the topic in which I'm speaking to, whether people are entitled to take leaves and also what happens for the people who are already on leave. Employees who become incapacitated due to a serious health condition caused by a disaster may be eligible to take FMLA if the employer is a covered employer. An employee whose family member becomes incapacitated due to a serious health condition may also be eligible to take FMLA if the physician or other healthcare provider provides that the employee is needed to care for the family member. And I have a couple of examples here. One is where the employee is injured in a tornado, and he or she is at work. And so I'm saying separate and apart for workers' comp issues, this individual may be eligible for FMLA if the employer is a covered employer. Another example is the employee's mother's home is damaged due to a mudslide, and the employee asks to take FMLA to help clean the mother's home. That's not a situation in which the employee is eligible because the family member doesn't have a serious health condition. She simply has a lot of mud in her living room. And a final example is the mother has had this mudslide but was trapped in the house and is now suffering severe PTSD. The mother's physician certifies the employee is needed to care for the mother, and in that instance, the employee very well may be eligible to take FMLA leave in order to care for his or her mother. Now, regardless of whether the employee is eligible to take FMLA, if the weather or natural disaster causes or exacerbates a disability, as defined in the ADA or other state statute, the employee may be entitled to take a leave of absence or some other reasonable accommodation. So some examples I've given are smoke from fire exacerbating asthma. The employer now says, I want an air purifier in my workplace. That would likely be viewed as a reasonable accommodation. Employee who's trapped in a skyscraper during an earthquake has PTSD and wants time off. That might be another example. Remember, and for all of you who know the ADA, the employee doesn't have to use the words ADA, doesn't have to use the words accommodation. They simply need to make a request, either for time off or other accommodation. And that triggers the obligation on the part of the employer as well as the employee to engage in an interactive process to discuss the nature of the disability and the accommodation being requested. And my warning here is that before an employer refuses to give a requested accommodation on the grounds that it causes undue hardship, they need to be very careful because undue hardship is a tough defense to prove, and the employer has to show that it's undertaken a lot of different analyses. Certain protected leaves of absence have duration limits. FMLA is 12 weeks. California pregnancy disability is 4 months. And so if the business is closed, does the employee get charged for those days? Well, for FMLA, the federal regulations say that if the business operations are closed for a full week, those business days do not count against an employee's FMLA. But let's say the business shuts down for 3 days out of a work week, and the person is on FMLA that entire time. That is still going to count as a full work week of FMLA leave since the business was open for some portion of that week. And the same regulation says that if there are holidays that fall during a week, the full week counts against the employee's FMLA bank while they're out on leave. Okay, so we also have to consider USERRA. And I need to speed up a little. I'm running a little past. But USERRA may apply if you've got an employee who's part of an emergency services organization like the National Guard and is called into service. The USERRA only requires the employee give advance notice of his or her service, and the notice only needs to be timely. So you may have people in your workforce who say, hey, I'm part of the National Guard, and I've been called up, and I need to go help out. And they give you that notice the day before. You're going to need to accommodate that. I'll now move to the use of vacation and PTO. And so in the aftermath of severe weather or disaster, an employee may actually request to use accrued vacation or PTO to address personal needs, cleaning up the household, caring for their children, and so forth. This is the place where you might want to think about having your time off policies address this in advance so that you don't need to be making these judgments on the fly. And if you do have some policies, you certainly can require, you can say you can use your vacation time, but you need to give a certain amount of notice. Do consider the negative PR if your policies are too tough or if you're inconsistent in how you apply them. Remember that in the aftermath of disasters, there's a lot of public sentiment and sympathy for employees. And so, I think that most businesses would do well to do whatever they can reasonably to assist employees. But again, recognizing that if you have all of your employees out using their PTO, you can't run a business. So you want to think about that. You want to think about what you will do for employees who actually want to assist in community efforts. For example, in the aftermath of Katrina, there may have been employees who say, look, I would like to take my vacation time and pitch in and help. And so that's another situation in which you might want to address that in advance. Now, my last slide said employer not required to accommodate request except, and that's a typo. This is a situation in which, again, assuming that they aren't a member of a force that is called upon to assist, you don't have to let them take their vacation or PTO time to assist in community efforts if your policies actually require advance notice. If, on the other hand, you have routinely allowed people on very short notice to say, hey, my spouse has a conference in Hawaii, and we would have to leave tomorrow. I'd like to go. If you've done that, then my counsel would be, to allow the person who wants to take immediate vacation time for community cleanup. So I am now going to turn over the conference to Will, who's going to continue telling us in detail about some further absence issues that are implicated by inclement weather and disaster.
Yes, thank you. This is Will Hannan. I'm going to be speaking to you all about various issues relating to when there's weather-related absences and tardiness issues. My personal background, I come from a labor background, but the vast majority of my presentation will relate to all workplaces, not just unionized workplaces. Now, when an employer is dealing with weather-related absences and tardiness, it's generally up to employers to decide how to handle. Obviously, there may be some legal implications and requirements, but generally, for policy issues, it's up to the employer to learn how to handle. Some exceptions to this are unionized workplaces where there's a collective bargaining agreement. Certain topics relating to weather-related absences and tardiness and other issues may be negotiated in CBAs, or if there's individual employment contracts with particular employees, there may be some negotiation over that in those contracts. The best practice to have for when dealing with these types of issues in the employment context is to create a thorough and reasonable policy that creates an objective framework for how the employer deals with these issues, as well as puts employees on notice as to what to expect when these issues arise. I think the worst scenario is when the workforce is confused about what's going on and generally is not sure how to react. They don't know what the implications of staying home are, reporting to work, etc. So I think it's important to make sure everybody's on the same page in regards to that. Now, in terms of creating a policy related to weather absences and tardiness, there's a multitude of topics that generally is a good idea to include in those policies. The first is if there's a weather or other weather-related or other disaster, who decides if the facility, office, or plant should be closed due to that issue? Related to that is what criteria is used to determine. One sort of good objective framework would be to rely on some sort of government declaration, whether the governor declares a state of emergency, as we in the Northeast had several times this year, particularly in my state of New Jersey. There were several states of emergencies declared, and that's a pretty black line test as to when weather conditions are predicted to be severe enough to perhaps consider closing your facility. Additionally, on a more local level, if there's a public transportation shutdown, depending on what type of geographic setting you're in, if you're in a more urban area, that may prevent a lot of your employees from reporting to work, even if they wanted to. That may be another good objective factor to use when considering whether to remain open or to close down for the day. And the second and the third, which is a little more superfluous, is the occurrence of a specific weather event, a particular amount of inches of snow, inches of rain, that sort of thing. But of course, that can vary greatly depending on what the time frame is for that. So it's probably best just to use a more objective standard that you can rely on, when these events occur. A second thing that should be included in a weather absence or tardiness policy is how are employees informed of the closure. It's important. The considerations are, you don't want employees to be on the road to try to get to work if you're going to close down. But on the other hand, if the employer decides to remain open, employees need to know whether they need to come in and how to balance their safety and their other personal needs in deciding whether to try to come in or not. Larger companies may have a weather hotline where a phone number and extension is given to employees. They can dial in prior to their work shift, and there'll be some sort of pre-recorded message letting them know what the status is, whether there's a late opening, or whether the business is closed down for the day. Nowadays, it's pretty easy to get in touch with your emails with your employees via text messages or email. There may be robocalls. A phone tree is a way to have your workforce sort of distributed to each other, sort of rely more on the employees to distribute amongst themselves. I think TV radio is one that is used for schools and other public entities. Probably not quite as relevant in this day and age when there's a lot more access to information, and it's probably not the most efficient way. Or if there's just a generally known occurrence of a specific event, if the local schools are closed, if the county offices are closed, the employees will know that they don't need to come in that day. Some other issues that would be relevant to include in a policy, as Jennifer related to in this modern workforce environment, can employees work remotely? If employees are able to work remotely from home, this alleviates a lot of the issues, whether people need to come in, whether it's safe to go on the roads, and whether they need to be compensated for time when the office is closed. If employees are capable of working from home, it takes away a lot of those issues and creates added flexibility for both the employer and the employee. Something that I'll be going into detail a little later in my presentation: when are absences or late arrivals considered excused or unexcused in the context of weather events? Going off on that, if the company is open but an employer cannot get to work, what is the proper call-in procedures when an employee cannot report to work due to transportation or other issues? Do they call their department? Do they call a main line? You just want employees to know how they can get in touch with the company in a way that their call-in will be recorded and observed. As Jennifer spoke to in the first portion of the presentation, compensation issues, I think it's good to outline those to employees so they know what to expect. the effect of states of emergency or road closures. If an employee hears on the radio or on TV that the governor has declared that the roads are closed as a state of emergency, I think employees need to know if that releases them from an obligation to go to work, or if they need to further check in with their employer to check in what the status of the company is. And as related to in the first portion of the presentation, can employees use paid time off or vacation time to cover absences, or does the employer force the use of paid time off or vacation time? These are all issues that will reduce uncertainty in the workforce, and will, even in the context of an unexpected weather event, will help things to go a little bit more smoothly. Now I'd like to get into the issue of employees refusing to work and discipline issues when there is a weather emergency, but certain employees may not be able to come into work due to transportation or personal issues. If schools are closed, they need to stay home to care for children or a relative. One important distinction in this category is the difference between essential and non-essential personnel. And this is you see this distinction typically in operations that operate 24 hours a day, 7 days a week, hospitals, long-term care facilities. In the healthcare setting, I think it's pretty obvious that that would relate to care providers, nurses, LPNs, CNAs, doctors. They're the people who provide the direct care and need to take care of the individuals who they are charged with taking care of, who are obviously going to be in the facility or the center, regardless of what the weather is outside. But it may not be quite as obvious, but also the support staff of a facility like that are also often considered essential personnel. And this could include dietary, all the people in the hospital, including employees, if they're trapped there, they need to have their food and drink taken care of. And also, particularly in a healthcare setting, housekeeping, in order to maintain a sanitary and infection-free facility. A lot of employers consider even janitors and custodians to be essential, particularly if there is an emergency outside. It's important to keep the facilities clean and everybody safe. And one thing I did include on the side, obviously, policemen, firemen, emergency personnel would also be considered essential personnel who are expected to report to work no matter what the weather or disaster that may be occurring. Now, if a workplace is open, an employer says we're going to remain open, or in the context of if a workplace does close down but essential employees are still required to report to work, the issue of whether to discipline an employee who says they cannot get to work or that it's impossible for them to get to work is usually viewed in the context of the just cause standard. And this can be in public employee settings where there are state protections as to employment for civil servants, or in the unionized workplace setting where there is a just cause for disciplinary action standard in the collective bargaining agreement. And generally, these types of cases are determined on a fact-heavy, case-by-case basis. And the key determination is when an employee is required to show up. And again, and that's because the company is open, the employer is open, or if the employer is shut down, but you're an essential employee. The question is whether it's possible for that employee to get to work under their circumstances. If it's truly impossible for an employee to get to work, if there's 20 inches of snow and the roads are all closed, and you live 20 miles away from your employer, and just there's no way, it's unlikely that disciplinary action would be imposed based on that standard. But if it's a situation where the public transportation was still running, but the roads were a little slick, it's likely that an employee would still have the obligation to show up. And of course, that relates to those situations where there are certain employee protections. In the at-will situation, obviously, an employer is free to take whatever disciplinary action they want against an employee, sort of no matter whether it was justified or not. In relating to facilities or workplaces that do need to stay open during a weather emergency, one thing that employers may want to consider is to create incentives for employees to stay and to make sure they get into work, rather than to threaten employees with disciplinary action or termination if they can't get to work. Some of the unions I represent are in healthcare facilities, and if there is an anticipated weather event that's coming, there's going to be a big snowstorm or a hurricane, a lot of times employers will create incentives for employees to just stay in the facility in advance of the severe weather, so that the issue of transportation, getting to and from work is not going to be an issue. I think the best way to do this is to request volunteers to stay during harsh weather and make overnight accommodation, meals, and probably the most important factor, to make sure you pay them a premium rate so there's an incentive for them to stay for potentially 24, 48, 72 hours, depending on how severe the weather emergency is. And I think the volunteer approach is a little more reasonable than just going off a mandatory type system, because obviously some people are more available to stay for extended periods during emergencies than others due to family situation. Again, if schools are closed and there's no child care, or if a relative needs to be taken care of, or if somebody relies on public transportation and that's shut down, an employee may be put in a position where it's impossible for them to get to work, but they're not excused, so it can create a difficult situation. Now, the situation where there's a weather emergency, the employer decides to remain open, and an employer refuses to report to work. Now, again, I think usually employers, whether it's a requirement or not, requirement if you're in a jurisdiction with civil service protections, or if you're in a unionized setting with a collective bargaining agreement, even if it's just based on policy, I think it's important for policies to be flexible and to try to strike the balance between the employee's need for safety and management's need to keep the business open during a potentially severe weather incident. And I think it's important to remember that the choice for employees is a difficult one. In situations where the weather is severe, but they still have to come in, the employee has to weigh, risking injury by braving the severe weather, taking their little two-wheel drive car out in severe snow and storm, slick roads, or risk disciplinary action or termination by staying home. So I think it's important to view these things on a case-by-case basis based on the employee's circumstances. Now, on one hand, you don't want to have a blanket exemption, because if an employee calls in at the first snowflake that falls, obviously that wouldn't be something where the employee would necessarily need to stay home. But if it is a true emergency and the employee's circumstances dictate that they are not available to get to work, I think it's important to take that into account. That being said, there's few protections for workers who are disciplined or fired for non-attendance during bad weather. Generally, obviously, the United States, except for one state, I think it's Montana. Somebody can correct me on that if I'm wrong. Basically, every jurisdiction is an at-will jurisdiction unless there are state laws in place or collective bargaining agreements. And if an employer decides to stay open and an employee cannot get to work, the employer can take disciplinary action against them or terminate their employment based on that. There's really no legal protections about that. That can be invoked, except in limited circumstances. However, I'd caution employers to try to come up with a more flexible approach, certainly putting somebody in a position where they'll face discipline or termination because they can't report to work. It's a pretty harsh penalty to impose on somebody when they're in a difficult set of circumstances, and I think that can have a negative effect on employee morale for other employees in the workplace who see that sort of harsh treatment. And also, in certain circumstances, that could also have a negative PR effect as well. If there's a severe snowstorm and a worker is terminated because they have a story where they have to care for their elderly parents and their school children who are sick and they can't get to work because they can't go up treacherous roads, I think that really doesn't make an employer look good. Now, in terms of the limited circumstances which afford some protection for employees during harsh weather events, the Occupational Safety and Health Act protects employees working in extreme weather. And I'm not going to touch on this too much. I know the third segment of our presentation today will cover that more in depth. But just to touch on that a little bit in the context of discipline, OSHA generally does not cover workers who cannot report to work due to transportation issues or other personal issues when actual performance of job duties is not made unsafe. What that basically means is that OSHA wouldn't cover you if it's dangerous to drive to work, It really covers you in the situation where if you are working, if you work outside, or if driving is part of your job duties, for example. If the conditions are unsafe, there is some protection, some sort of limited protection based on the circumstances, again, to refuse to work under those conditions based on that law. And again, touching on one industry that's certainly the performance of the job duties takes place within harsh weather or other elements. Commercial truck drivers, there is a federal law called the Service Transportation Assistance Act. This law prohibits employers from disciplining or terminating commercial drivers for refusing to drive commercial vehicles on highways in violation of federal safety regulations, and that is more expansive than just harsh weather situations, but certainly there are federal safety regulations concerning operating commercial vehicles in harsh weather elements that may create a public or individual safety hazard. The law also prohibits employers from terminating a commercial driver who refuses to operate their vehicle when the driver has reasonable apprehension of serious injury to self or public because of the vehicle's unsafe condition, and that can be as a result of the harsh road conditions and outside elements. But again, even with this limited protection in this industry, refusal must be reasonable under the circumstances. So really, all the disciplinary issues where there are protections, whether it be contractual in a collective bargaining agreement or in those few industries that have protections by law, the refusal has to be reasonable. There's no blanket exemption for employees, again, sort of seeing a little bit of rain outside and saying, I can't get to work. But it has to be a true harsh weather event where the employee's safety or the public safety would be put at issue if the employee were to perform their job duties. There's also some protection for refusal to work in harsh weather elements under the National Labor Relations Act. I think it's important to point out that the National Labor Relations Act, while usually viewed in the unionized context, can apply to unionized and non-unionized workplaces. And there's case law under the NLRA that does protect workers who refuse to work due to unsafe conditions under certain circumstances. Basically, the case law that's been established on that point is that an employer cannot retaliate against an employee who refuses to work due to an unsafe work condition. Again, in this context, a harsh weather condition. You'd probably be looking at an employee who is not having trouble getting to work, but is actually performing their work where the harsh weather conditions would affect them. The employee has to act in good faith, honestly believing that the work would be dangerous. If an employee is, for example, if an employee is ordered to do outside work and it's 10 below, that would be a situation where that employee could have a good faith belief that the work, being outside, having that exposure, would be dangerous to their health. And additionally, one important point under the NLRA is that the refusal has to involve more than one employee. And for those of you who may practice in the labor law field, that would be considered a protected activity. So it can't just be one. Even if one employee has a good faith belief that the work is dangerous, to be protected for refusal to work in unsafe conditions under the NLRA, it has to involve two or more employees. It can't just be one individual employee. And additionally, in the union context, the refusal cannot be a pretext for a work stoppage designed to get around a no-strike clause in a CBA. So you can't, again, going back to the example of seeing one snowflake out the window, you can't say, hey, geez, this is if you have a no-strike clause, you're prohibited from striking or taking other economic action against your employer. You can't use that one snowflake to say, geez, this is a great excuse for us to walk off the job and try to get better terms and conditions of employment in our contract. It really has to be related to unsafe working conditions. Jennifer touched a little bit on on-call employees and stranded employees in the first segment of this seminar, but I'll just go over this in the context of my presentation. If an employee is on call during a weather emergency, if the employee is in a position, whether they are on the employer's premises or at home, where they cannot effectively use the time for his or her own purposes, they do have to be paid for that time. However, if an employee is at home and their supervisor says, I'd like you to be available, keep your phone by you, but they can go read a book, they can have dinner, they can use the time for themselves, that would not be considered the type of on-call situation which would require an employer to pay an employee. But again, that would be up to the company policy whether that time would be, an employer can certainly be more generous than the law allows. For employees that are stranded in the workplace due to weather emergencies or other disasters, the same general rules apply regarding compensation that Jennifer discussed during the first segment of the presentation. An exempt employee must be paid their regular salary, even if stranded and unable to work for days. But again, that's basically for any part of a work week. If you're in a very unusual situation where you are stranded for multiple weeks, which I think would be very unlikely, it's only for the portion of the week that you perform your job duties in. And non-exempt employees, of course, are only required to be paid for the hours actually worked, even if you're at the job site. So even if a non-exempt employee is stranded at the job site, if they have time to themselves, if they're stranded there overnight and they go to sleep, they're not required to be paid for that time, even if they are stranded at the facility. The idea being that that sort of situation would be the result of an act of God and really wouldn't be up to the employer's discretion. Now, the last topic I'd like to discuss is unemployment compensation in the context of a weather disaster. And I think you all know that the state laws, unemployment is governed by state law, and those state laws can vary wildly. But generally, employees who are out of work for reasons other than their own misconduct are eligible for unemployment compensation. And again, I know I've used this term a lot during my presentation, but it's another situation where things are decided, looked on at a case-by-case basis, depending on the factual circumstances. And again, the key question, and again, this would arise in the context of an employer staying open and an employee saying, I can't get to work, and then that employee being terminated. The key question is whether the employee reasonably and safely could have reported to work. Looking at the example again, an employee sees a snowflake, say, hey, I can't go to work, it's too dangerous for me to drive. That probably would be considered some sort of misconduct or some sort of insubordination that may disqualify the employee from receipt of unemployment compensation. Probably not completely, but probably for a period of time, depending on how your states deal with minor instances of misconduct versus major instances of misconduct. But if it's truly unsafe for an employee to get to work, to have that good faith belief, and they're terminated on that basis, there's nothing that says, generally there's nothing stopping an employee from terminating an employee under those circumstances, but generally in that situation, an employee would be eligible to receive unemployment compensation if that was the basis for their termination. And the last issue, sure.
Go ahead.
The last issue I'd just like to mention is if there is a facility closure or damage, employees may be eligible for unemployment benefits if they're out of work, basically on a temporary layoff if there is a situation where they can work, but the work is basically made impractical because of damage to their facility or their office. And that concludes my presentation.
Okay. Well, we've got a question that I think touches upon something you raised. The question is, what constitutes use of time for own? It says policies, but I think they mean what is use of time for own purposes in terms of on-call? So in other words,
it may be a little clearer to sort of look at examples of that rather than trying to explain it. If an employee is required to be sitting by let's say the employee is certainly the employer is required to stay at the facility. And they need to be ready to. They need to have, if it's some sort of emergency responder, and they're required to have all their gear ready, and they need to be ready to go at the drop of the hat. Certainly, that would be a situation. And also, if they're prohibited from leaving the facility or from doing their own thing, if they can't use the time for themselves, that would be a situation where there would be on call and they can't use the time for their own purposes. Or even if employees at home, but they need to be ready to go at the drop of the hat, and they need to, perhaps they have the employer's vehicle or something like that, but they need to be ready to go, and they can't, take time for themselves. They can't. If they need to be available immediately, that would be a situation where they generally wouldn't be able to use the time for themselves, or they'd have to be paid for the on-call time. But if an employee is the typical example would be if they're at home and they can do whatever they want, but they just have to keep their phone by them and answer the phone and perhaps report to work if their supervisor calls them. That would be a situation where the employee would not have to be paid for their on-call time because they can live their normal life. They can watch TV, they can read a book, they can do whatever they want, but they just need to be available. It really doesn't impede in their off-work activities. It just means that if they do get called, they need to respond, and at that point, if they are called into work or called into action, that would be the point where the pay obligation would take place. But obviously an employer
Okay.
can have more generous policies where if they need to be available, they could be paid for that time.
Okay, thanks, Will. So now I'm going to turn it over to Joanna, who's going to speak to steps that can be taken to keep the workers and the workplace safe.
Thank you, Jennifer. I just want to jump in here for a minute, too. We've had a lot of information that Jennifer and Will have covered in their presentations, and we're definitely looking for your questions. So if we're going to try to answer them at the end of the presentation, but you might as well get them up in the queue. If you have any questions about anything that's already been covered or something that you something that relates to this topic, feel free to just load them into the Q&A panel there, and we will address them as probably more toward the end, but maybe as we kind of go in if they fit into what we're talking about. My talk, I'm going to be talking about giving you some practical considerations about how to keep your workers and the workplace safe. Inclement weather can mean a lot of different things to businesses, besides just the potentially loss of property or damage to property, damage to business assets. You could also be talking about injuries to workers. You might be talking about business disruption, lost sales. You may have employee problems with reduced productivity or reduced morale among your business. In short, inclement weather can mean a lot of extra costs and a lot of extra headache for your business. I'm up here in New Jersey where a couple years ago we were hit by Superstorm Sandy, and that took everyone by surprise in terms of I think we were out of power for about 10 days, something that is just unbelievable in the New York metro area. And everyone was in the same boat. People were out of power for a lot longer than that. And just how is your business going to cope with that? How are you going to deal with, we didn't have gasoline. That wasn't available. So how do you get your inventory in? How do your employees travel in and out of work if they even can? Working remotely is a great idea. But if they don't have internet access, you're going to have some trouble. So these are all kind of considerations that you need to think about. The key being preparedness. A lot of what Will and Jennifer touched upon, was to be prepared for the worst. So you want to plan ahead. A lot of it is going to be directed toward your specific business. And so think through what are some hazards that you might face in your business. Are you on the East Coast and you may have hurricanes and snowstorms and blizzards? Are you on the West Coast and you're more likely to have earthquakes and wildfires? Are you somewhere in the middle and you might have tornadoes? You want to, after thinking through all those issues that you might have, take precautions. Think about ways to make your workforce and your workplace safer. The second key, along with preparedness, is to communicate. It's great to have all these plans, but everyone, all your employees and your workers need to know what to do in case of an emergency. That's going to be the best way to cut down on potential injuries and losses. And then train management and your workers in all those in your plans. So we've talked about OSHA a little bit, the Occupational Safety and Health Act from 1971. OSHA's mission is to assure safe and healthful working conditions for working men and women by setting and enforcing standards and by providing training, outreach, and assistance. In addition to setting workplace safety standards, OSHA is charged with enforcing some whistleblower statutes and regulations, protecting employees from retaliation when they've either reported an unsafe working condition or in some limited circumstances where there are unsafe conditions at work and they have engaged in a good faith refusal to do that work. OSHA covers most private sector employees and their workers. Some public sector workers are also covered, federal agencies and state and local agencies through OSHA state programs, local programs. Those are not covered include the self-employed, immediate family members of farm employers, and if your workplace hazards are regulated by another agency, another federal agency, for example, if your workplace is a mining operation or something that's covered by another federal agency. Covered employers are required to provide a safe workplace. Well, what does that mean? You really were talking about recognized hazards likely to cause death or serious physical harm. You want to look for your hazards and reduce them, correct safety and health problems, and maintain records. As to chemical hazards, not so much weather-related, but sometimes talking about potentially de-icer or other chemicals. You want to inform your workers about them, provide safety training, and provide personal protective equipment where required. And OSHA also requires, for those employers who are covered, that you promptly report serious workplace injuries, which I meant inpatient hospitalizations, amputations, or losses of an eye. Those are the ones that they need to be promptly reported, as well as fatalities. OSHA also protects employees from retaliation or discrimination against workers who exercise their rights under the law, including making a complaint to OSHA or making sure that the employer files a report of a work-related injury or illness. So you think OSHA and you think about the actual, the day-to-day workplace. You think of factories and you think of machines, things that, can hurt workers. Well, it also has to do with inclement weather. OSHA's got a lot of good tips for having emergency action plans, as well as protecting workers from weather hazards. There are some employers that are required by OSHA to have an emergency action plan. I know Jennifer talked about some requirements for a plan, state-specific requirements in California. Certainly not every employer. But that is a consideration for certain employers. So what's a workplace emergency? And a workplace emergency is an unforeseen situation that threatens your employees, customers, or the public, disrupts or shuts down your operations, or causes physical or environmental damage. We think of weather events, floods, hurricanes, tornadoes, and earthquakes. Other times, sometimes related to things like earthquakes, you could have fires, you could have explosions. You may have loss of power or water or utilities. Certainly that was the case that we had in Sandy, that everyone was out of power for a long time. In a flood, you could have your water supply could be compromised. These are issues that will affect your workplace. Related to that, you could have a lot of problems with employees who are unable to travel, or potentially either get stranded at home or get stranded in the workplace, or maybe they're on a business trip, or you've sent them out someplace else to go. Excuse me, sorry, I'm suffering terribly from allergies. I apologize if tell me to speak up. You may also have a problem with lack of supplies. Either roads are closed and shipments can't get to and from you, and potentially civil disturbances and workplace violence. We certainly hope not, but that's always a consideration. You need to be prepared for those. So what does OSHA recommend? OSHA recommends you create an emergency action plan. It's something that Jennifer and Will talked about in terms of preparedness. The emergency action plan is going to cover designated actions employers and employees should take to ensure employee safety from emergencies. The best emergency action plan is going to be one that's tailored to your workplace and your workforce. Talking before about, are you on the East Coast and hurricanes are a concern? Are you on the West Coast and maybe you're talking about wildfires? It takes just a little bit of time to sit down and think about what are the real risks that are going to be facing your workforce. Also, you may be an employer with multiple locations, in which case you may have different emergency action plans for each region or each facility. Also want to caution here, we've talked about potential loss of employee records and employee data. It's great to have a paperless office, but what happens when the power's out? You want to make sure that you've thought through every contingency, and so maybe having a binder with the emergency action plan and a few key employees' cars or homes may not be a bad situation. So what should your emergency action plan include? According to OSHA, you want to have a preferred method for reporting emergencies, including fires or explosions. You want to have an evacuation policy, a way for employees to safely exit the building or the facility. Including with that, how to emergency escape. So not your orderly fire drill, everybody out the door, but what happens if part of the building collapses. You want to have everybody know how to get in and out, where to go, to a safe place, and post floor plans and maps. You want to have identified key individuals by name, title, and department, as well as contact information, like telephone numbers that you can reach them. It should additional information be needed for how to proceed in the case of an emergency. You may also have key plant operations that need to get shut down, maybe machinery that takes a lot longer to shut down, or operating fire extinguishers. You want to have identified those employees who remain to perform these critical activities as well, so they know who they are, everyone else knows who they are, and they know what they need to do in that sort of a situation. If you have employees who are able to help you with rescue or medical duties, I will talk about hospitals. You want to have designated which employees should be performing those duties and how they can perform them safely. Another consideration is how you account for your employees after you've had an evacuation. You certainly don't want a situation where you're not sure if everyone has made it out of the building. We've seen around here a lot of people have had little barcode readers. I thought that was interesting, where everyone's kind of a portable one that all the employees will scan their ID cards, so you know that everyone who's at work that day has already been accounted for. I thought that was a very smart idea when I saw that one. Now, it may seem like a little bit of overkill to have an evacuation plan, but really it's going to be what keeps your workers safe, because they're going to know how to respond in the case of an emergency. They won't be confused, and maybe you can avoid some injuries. You want to have a plan as to what conditions would require an evacuation from your building. Is it a fire? Is it a certain alarm? Is it if you have an earthquake, are you leaving the building, or are you staying in a safe place? Chain of command as to who orders whether or not there's an evacuation. You don't want a situation where every other person on the floor, half the people say it's time to leave, and the other half say no, we need to stay, and no one's in charge to say what should be done. And you want to have identified that person who's authorized to order the evacuation or the shutdown. Now, you may have people in your workforce who need special help, either getting in and out of the building, maybe hearing an alarm. That could include people with disabilities or people who have communication issues, whether they don't speak English or don't read. So you want to have identified those people and be able to help them participate in the evacuation. And then designation of key people and accounting for everyone. You want to make sure that your evacuation plan makes sure that everybody gets out the door. Good emergency action, you really need to have the key communication with your employees, including disabled workers. So don't just think that your public address system will solve all those issues. Employees should also know what an alarm means. Alarm should be distinctive. Is it an alarm to evacuate? Is it an alarm to wait for more information? This may be your public address system. Maybe it's a portable radio unit. Maybe it's another way to contact employees. We talked about a robocall, or maybe an automated text message that goes to everyone. Training, you both have to communicate the plan to your employees, and then you have to train them on them. Practice makes perfect. All employees should understand their role. What is it that they are supposed to do in the event of an emergency? So if you have key personnel, who, maybe managers who need to take on a more leadership role during an evacuation or during any kind of emergency, they should know who they are, and they should know what they need to do. how to protect against hazards, whether it's a fire extinguisher or keep yourself away from chemical spills, how employees should receive notifications about whether there is a shutdown or a closure due to an emergency. How are you going to get that information out to the employees, as well as where to go and how to keep yourself safe once you've left the building. Do you have a situation where perhaps your facility is fairly isolated, and if something, there's some closure or emergency shutdown, how are employees going to get in and out? Maybe a good idea as well to talk about specialized training, first aid, bloodborne pathogens. Now, how often do you need to train? OSHA recommends that you train certainly annually. After the development of an initial plan, if this is the first time you're creating an emergency action plan, or maybe you're expanding or centralizing your functions, after you've settled upon a final plan, make sure you've communicated to everyone and you train on it. Again, any kind of big updates to the plan, if there are any changes, you want to train again. If you've had a situation where you've hired on a lot of new employees, or maybe you've expanded into a new area, a new facility, or you've changed your facility so that your old floor plans and your evacuation plans no longer apply. When you practice, make sure that you don't just go through the motions. Identify what worked well and where you could use some work, and identify ways to improve. Now, before I get into specifics about cold weather and hot weather and how you can protect your employees during those sorts of weather issues, it's important to keep your employees safe, just from a physical aspect, so that they don't injure themselves. You can are concerned about physical injuries to your employees. There's also, as Jennifer and Will pointed out, a lot of considerations about employee morale and public relations considerations that should be thought about when you're putting your emergency action plan together. Certainly up here in the Northeast, we had plenty of cold weather this winter. So this was something that was very timely for us. There are some injuries that are specific to cold weather, including hypothermia, frostbite, and trench or immersion foot. Now, it doesn't have to be absolutely freezing temperatures outside to have these cold-induced illnesses. Factors that contribute to them include wetness or dampness, insufficient or improper dress, or just plain being tired. You've been working for a long time, and the cold is going to get to you a lot faster. You may have pre-existing health conditions that affect things like diabetes may affect your circulation, or you just may have an employee who's out of shape. So be aware when the temperatures drop, or if it's not even that cold, but your employees are out doing work in wet weather, that they could come up with some of these cold-induced illnesses. And a lot of this information, I understand the PowerPoint is going to be available for everyone, so maybe good resources, even if we're looking outside right now and it's sunny and nobody's thinking about hypothermia. But hypothermia is your most likely cold-related illness. It doesn't have to be freezing, but the idea in hypothermia is that your body heat is lost faster than it can be replaced. And so your normal body temperature drops to less than 95 degrees. Situation, it could be certainly above 40 degrees if you're talking about cold or dampness. In severe symptoms for hypothermia include body temperature dropping, loss of coordination, confusion, disorientation. The worker may not be able to stand, pupils become dilated, pulse and breathing become slowed, or loss of consciousness. Hypothermia is serious. You can die of hypothermia. Obviously, if you have an employee who's exhibiting any kind of illness, you need to be calling in further medical help for them, whether that means calling 911, perhaps you're a manufacturing facility and you have a nurse on staff, but you need to get that worker help soon. You want to warm the person gradually. If they are covered either in wet clothes or they've become wet, cover them with, take off their wet clothes and give them dry clothes, lots of blankets. Frostbite, unlikely for your office workers, but potentially if you have workers working either outdoors or in situations that they're not used to. Frostbite is an injury to the body caused by freezing of the skin and underlying tissues. They're looking particularly fingers and hands. Amputation is unlikely, but may be the case in severe cases. You want to look for reddened skin that develops gray and white patches, numbness, feeling that the tissue is firm or hard, potentially blisters in severe cases. So what do? You very slowly, don't try to rewarm them. Just cover and protect the tissue. Make sure the person is comfortable. And the person is alert. Don't rub the area. Be careful just about tissue damage. Now, immersion or trench foot is prolonged exposure to wet and cold temperatures. So basically, if someone who's standing around in the water, maybe you've had flood and or snow that's melting, and that worker is outside in a situation where they may be getting something like this. So basically, that's something OSHA has identified as a potential cold hazard. Key is to dry the foot. Snow and ice is another cold weather consideration. You want to keep your workers safe by keeping your facility clear of snow and ice hazards. Remind employees to walk carefully, maybe wear rubber-soled boots, and avoid sending your employees to places like, oh, go shovel off the roof. I know that sounds crazy. We've seen it. Those are not situations that you want to be in. You want to watch out. Use common sense. You also have, on the opposite end of the spectrum, you're going to have concerns about heat stress. If you have workers who are working in especially hot environments, maybe it's hot and muggy, maybe you had a power outage due to a storm and your air conditioning is out and your employees are working in a building that's rapidly getting very hot and uncomfortable. We'll watch out for heat stroke, heat exhaustion, heat cramp, heat rashes, and heat fatigue. All these illnesses have different symptoms, heat stroke being the most serious. But the key is to keep as much as you can, keep the workplace cool. General ventilation, air treatment, air cooling, offer a lot of fluids. Maybe if you have a situation where, like we said, the power went out and you don't have air conditioning, you might need to take consideration to having workers maybe slow down a little bit or reschedule jobs that involve a lot of manual labor in a hot area. Earthquakes. Certainly something that is more a concern on the West Coast, although we have had a couple little ones here in New Jersey. You want to pick a safe place for workers to shelter in place. Make sure you're not standing near any furniture or heavy items that could fall on you. You should want to instruct your workers to wait in a safe place until the shaking stops. and then look around to your environment. Is there a fire? Is there a broken gas line? Is there a damaged appliance? Maybe if you're outside at an earthquake, stay outside. Move away from the building, move away from trees, anything that could fall on you. Again, if you're in an earthquake-prone area, this may be something you want to include in your training for your employees to make sure that they know what to do in case of an emergency, or in case of an earthquake. Floods, if you're in a flood-prone area, you know the water is coming toward your building, you want to try to keep the water out, whether that's with barriers, with sandbags, and whether it's removing employees or moving key equipment further upstairs to an upper floor so that you're avoiding damage to it, as well as concerns about power. So just this information is here for you about being safe in a flood. OSHA also, I just want to mention this briefly in terms of hazardous materials. Not every employer is going to obviously be in a situation where they have a large number of hazardous chemicals or other hazardous materials on site. If you do have hazardous materials on site, you need to label them, train employees how to use them, keep an inventory of what you have. That's what OSHA is going to require from you. But you also want to think about your off-site risks, especially when it comes to weather considerations. Is your work site located near a chemical factory? Is your work site located near a power plant? Is your work site located near a rail line where chemicals are shipped in and out, and you could potentially have a derailment and a spill issue near you? So it's not just, what does your workplace have what are within the four walls of your work site. You need to think about the bigger picture outside it as well in terms of keeping your employees safe from those risks.
Joanna, we're almost at our Q&A point, so I'm going to ask you to finish up your last few slides.
Absolutely. You could obviously, and moving through here, you could take a lot of precautions, you can do everything right, and still sometimes you may have worker injuries. Most of your workers' injuries, if they arise out of the course of employment, are going to be covered by workers' compensation. You've got, I'll move through that. Benefits for it's a trade-off between the employer and an employee. The employee loses the ability to sue for tort-type damages, but instead gets a faster and more reliable dispute resolution method. Rising out of it in the course of employment is what we're talking about. In terms of weather conditions, you might want to think about what your workers who are either commuting. Generally, your commute, injuries during your commute are not going to be covered by workers' compensation. But maybe you have a special consideration in that you've directed an employee to travel somewhere during a weather event. These are sorts of injuries that could be covered by workers' compensation, as well as workers who are working from home during inclement weather. OSHA is not going to come in and inspect your home office. That's actually something that they've issued some guidance on. They're not going to come inspect it. But if you're injured while you're working at home, that could be covered by workers' compensation.
Okay, I'm now going to go ahead and take some of the questions and pitch them to some of my colleagues. One of the questions that I guess I'd like to direct likely to Will is a question that was, can workers or employees be disciplined for failing to be available to receive employer communications during disasters?
I think you have to look at the context you're in. Having an employment be at will gives an employer the authority to discipline or take other action against an employee for any reason, so long as it's not prohibited by law, which that type of conduct wouldn't be prohibited by law. But in terms of whether it's a good idea, I think if there's a I think again this is a situation where it's not a bad idea to have some sort of system set up where employees know how they're going to be contacted, if and when they're going to be contacted by the company, if their job responsibilities include being ready to be called in or just to receive communications. But I think if it's if it's a situation where perhaps the workplace is closed and the person is working from home or just at home, if they're on work hours and you're not able to get a hold of them or whatnot, that might be a situation where discipline could be issued. But I think you'd have to really look at what the situation is, and if the person is unavailable because they're outside shoveling snow or dealing with flooding or something, or if they're in their basement watching a movie or something like that. So I think again, so much of this is really just depends on the facts of the situation. But an employer would have the authority to take that sort of action against an employee for not answering an emergency communication if they chose to do so.
Okay, back to the questions. I'm going to take the next question. And the question was, if an employer is not subject to FMLA, but voluntarily permits family leave, does that subject the employer to all the FMLA rules, or is everything discretionary? And what I would say is, if you are not a covered employer, then you should characterize any leave that you do give as discretionary. I would recommend a letter documenting the leave as discretionary, that it is not family leave, and most importantly, it's not a protected leave. So, with FMLA, you've got the reinstatement rights, you've got the 12-week entitlement, and so my recommendation is that if the employer is not subject to FMLA, give limited duration personal leave, but make sure you characterize them as such so that you don't create a pattern or practice of having basically given FMLA leave when you're not obligated to, because there will come a day when somebody will say, well, you gave that person 12 weeks for a medical condition, now I want it. So that is my recommendation. I've got a question that I'd like to pitch over to Joanna. The question is, do we have any thoughts on an employee who has hypothyroidism, who as a result is very bothered by cold indoor temperatures? The facility itself makes it difficult to maintain even temperatures throughout the year.
Interesting question. I know that we addressed the idea of cold injuries under a workplace safety concern. There's no particular requirement that the employer provide either an air-conditioned environment under OSHA. But if you're talking about hypothyroidism, you might be getting yourself into a question about does the employee have a medical condition that you need to accommodate? And so you might be getting into that particular kind of more of a disability analysis rather than a workplace safety analysis. It's saying that they're bothered by the cold indoor temperatures. Your facility is difficult to maintain a consistent temperature. Again, it sounds like you might be getting yourself into the question of undue burden to accommodate that worker's needs. I think that might be more of a disability concern than a work environment cold stress concern. So I think you may just need more information from the employee. Are they coming in with a doctor's certification that says that they need some help? Is this something that you can easily accommodate them by either moving them further from a window or moving their workstation near a window? I think that's going to be very...
One of our participants wrote in with the suggestion, provide them with a space heater.
That is a great suggestion, absolutely.
So another question that we had is, in an emergency plan, how do we deal with the evacuation of employees who may not be able-bodied, who may be in wheelchairs? And I will address that. I would say that it's important to know this in advance. In my office, we have individuals who would not be able to ambulate themselves down, 30 flights of stairs. So we actually do have designated people, a number of them, who are willing and able to help evacuate these people. Similarly, during a fire drill, we've received building clearance for certain such people to remain in their offices in the event of a mere drill. But again, they always have to be accompanied by someone who remains with them. So these are things that you need to sort of plan in advance and basically have the volunteers lined up, have your action plan on how you will evacuate somebody who's in a wheelchair from your building.
Definitely, Joe. I think, definitely need to talk to that employee as well about how they might want to handle it. They may have good suggestions. And so, communicate with them. Get them involved in that part of the emergency action plan.
Okay, here's another question that I'll throw out to Will or Joanna. Somebody is questioning whether or not they need to repeat or replicate a building manager's plan that addresses fire and other disasters in their EAP.
I'll take a first stab at that one, and then if anyone has any other thoughts. I think that's going to very greatly depend on your building manager, or how your building is set up, I should say. If you're one of 20 tenants in a large office building, it may be better to have everyone coordinate by including the building manager's plan in your emergency action plan. If basically the building is yours, you don't own it, someone else owns it, so they have their own plan. But your employees are the only ones who would be getting in and out in case of an emergency. It may make sense to reference that building manager's emergency action plan to coordinate with it. I think the key is really just what's going to be the least confusing way to keep everyone safe.
Okay. We are getting close to the end of our session. If there are any other questions, please type them in and send them to us now. I'll leave the lines open for a few more minutes to see if anything else pops up. But I think while I wait and see if there are any other questions, we hope that today's webinar has been helpful in giving you some food for thought. And I think if there's a takeaway overall, it's really that disaster preparedness, severe weather preparedness, the key there is preparedness. It's thinking about the issues, developing plans, developing your procedures before we are faced with the actual disaster or the actual severe weather. And I think it's too easy for all of us to get caught up in day-to-day life and not worrying about disasters, however unlikely they may be. But I think that having some advanced thought, advanced planning is what is going to make the difference for businesses, those who are completely disorganized and don't know what they're going to do, and that can create, pandemonium, versus employers who've thought it through, developed a plan, educated their workforce on what the plan is. I think that's important. So my recommendation would be that employers think about these issues, develop a written plan, vet it among yourselves, get input from outside resources as necessary, and then importantly, all employee training or all employee communication on the issue. I think that is the way that you're going to educate everybody and have people behave appropriately when and if an emergency hits. And so we don't have any further questions on the Q&A bar. So on behalf of all of the speakers today, I'd like to thank everyone for participating. And we'll turn this back to Kathleen if she has any closing remarks before we close the live line.
Thank you so much. And on behalf of LexisNexis, a big thank you to Jennifer, Joanna, and Will for an outstanding program today. For our attendees, please take a moment to complete the survey that will appear for you. It provides us with excellent feedback so that we can continue to tailor programs that you want most and ones that meet your needs in our best way. Thank you all, and have a great day.